off, so I'll maybe just step on the accelerator a little bit. I've been asked to just do an introduction to the European Commission Modernisation Programme. Obviously, to understand the Modernisation Programme, we need to know a little bit also of what are the current problems. So I'm going to meld the two a little bit. And the background to the Modernisation Programme has been essentially a very extensive green paper, which is in large part a questionnaire as well. It posed, I think, something like 164 questions, which was published in January 2011. And that kicked off a consultation period that went on through most of 2011. There was an open invitation or a formal invitation to submit views and in particular responses to the questions posed up to April 2011. And then on the 30th of June 2011, there was a sort of a colloquium in Brussels when the Commission collated a lot of the views received. That was both a kind of a substantive collation, but also things like, what percentage of the respondents are local authorities, or what percentage are tenderers, all that sort of stuff as well. And then there was a very extensive reform package published by the Commission just before Christmas on the 20th of December 2011. And that included really quite extensive substantive treatment. It proposes to replace entirely the two existing main directives which have governed public procurement law for the past number of years, the 2004 directives. One on the public sector, one on the utility sector. So proposed to be replaced in their entirety with significant amendments in the new draft directives as published. There's also, for the first time, a draft directive on concession contracts, which is a world unto itself and which has been, to a considerable extent, outside the formalities of regulated public procurement law. Oh, thank you so much, Dermot. Outside the formalities of regulated procurement law. Up to now, and the Commission has on a number of occasions signalled its unhappiness with that, because really very large contracts, particularly service concessions, which are formally and acknowledged in the 2004 directives to be outside regulated procurement, very substantial contracts have been let without any regulation of the procurement, other than the somewhat uncertain general principles of community law or general treaty principles, and which really suffuse the entire of public procurement law. They're principally equality, non-discrimination, transparency, proportionality. And you can never forget those when reading the raw text of any procurement directive, regulations, whatever, in any of our relevant national jurisdictions. So the entire reform package is two completely new public sector and utility sector directives, and then a brand new, for the first time ever, draft directive on concession contracts. Concession contracts essentially are where the reward for the concessionaire who takes on concessionaire risk is exploiting the asset or the service. A classic would be if you have the contract, for example, to operate the tram system in Nottingham or in Edinburgh or in Dublin, wherever it happens to be. The concessionaire runs the risk of not enough passengers or too much congestion on the streets or whatever it is, but doesn't actually build the tram system to put it in. So it's operating and deriving, as it were, its income from the exploitation of that service. The timing and the implementation, as published by the Commission and envisaged by it, is really quite ambitious. They envisage that by the end of calendar 2012, all of the further deliberations and legislative processes would have been completed. And on that basis, the new directives would come into national law in the end of June 2014. Personally, I think that's very, very ambitious. It remains to be seen. But things are cracking ahead at a pace. And in Brussels, as we speak, there are working groups from all of the member states, chaired by the Commission, discussing the various elements within the new draft directives, which are divided up into what they've termed clusters. And some of them are in Eurospeak. I'm not being disrespectful, but one has to allow oneself a wry smile at times. One of them, for instance, is on flexibilization. You've got to rock and roll and with these things, and that's the way they're happening. But they are moving ahead at a great pace, and there are sessions planned for the Council of Ministers, the Parliament, and so forth, the various committees, right through the year. So watch the space. So if we were to just see what is involved in substance in the proposed reforms. And a couple of my colleagues will be speaking on particular aspects, so I'll pass very lightly over those, and it can only be a relatively quick tour of the subject matter. The January 2011 Green Paper was part and expressly part of the Europe 2020 project for smart, sustainable and inclusive growth. It's really to make Europe competitive against third countries, the States, the Japanese and so forth, the other trading powers, and also to do so in a way that is green and sustainable, and which in turn has particular implications for procurement law. And then the main objectives, I've just summarised on the slide there, they're set out in considerable length in the new documents, which incidentally run to over 500 pages, so they're quite a read, and this is necessarily a sort of a personal distillation of them. But the main objectives are expressed to be, first of all, to increase the efficiency of procurement. In other words, less formalities, less time, less bureaucracy, less law, certainly less litigation if that can be helped. They also seek to support better SME access, and again, some of our colleagues here, Nicolas Pourbet in particular, will speak on SMEs, I think, presently. That's particularly important for industries and small businesses in Wales, here in Wales, or in parts of the peripheral areas of England, and of course in Ireland as well. There are societal, what are called in the documentation, societal goals. That's social and environmental, and the so-called third pillar or third sector in society, which would include charity and public benefit and so forth. They have been a little bit woolly in the past. To what extent, for instance, can you prescribe in a procurement that preference would be given to the long-term unemployed, or to what extent can you prescribe specific environmental goals, targets, standards, be they emissions or be they maybe slightly less specific. And again, we just mentioned very briefly, but there's a lot on it in the directives, and they're seeking to put more meat and more concrete form on those, so that people can use those elements and do so without undue fear of challenge and so forth, and do it in a beneficial way for society. There are other clarifications as well in the draft directives, and which I think are certainly most laudable in their objectives. The only question is, do they achieve it by the right means? For example, one is material change. As a general principle, if you start a procurement, you shouldn't radically change it in the course of the procurement. Similarly, if you award a contract, you shouldn't radically change it without going back to the market, because the fear is it's actually a new contract and should have been offered to the world at large. So that's what material change is about, and there is specific case law which deals with that, and which the directives seek to make clearer. There's a little bit on the cleaning up topic as well, on combating corruption and favouritism and so forth. And there's some very, very interesting material on conflicts of interest, and which, frankly, I don't fully understand. It's very complicated, and I think it could usefully be teased out a little bit as the project goes ahead. On the efficiency side, one of the main changes, and here we're speaking in this presentation essentially speaking of the public sector, unless I say otherwise, and it was the public sector directive. Most of these things apply equally to the utility sector, and I'm not going to go into the concessions directive today, there just isn't time. But one of the main proposals is the abolition of the distinction between Part A contracts and Part B service contracts. In essence, for those of you who are non-lawyers, Part A are what are called priority services, those which are at the time that the legislation was enacted, that's to say most recently the last set of directives in 2004, which are transposed in the United Kingdom by regulations, national regulations in 2006. SI 5 of 2006, SI 6 of 2006 on the utility side. And Part A are those which, at the time the legislation was enacted, are thought to be those most likely to be of trans-border interest, that is to say, of interest in other member states. And there's therefore a much higher level of formalities attaching to them. Part B are the opposite, non-priority services, and they're in essence the only major requirements in relation to those are, first of all, to publish an award notice, secondly after the award, and secondly to adhere to standards and not to deviate normally from European standards. It is proposed to essentially abolish Part B and to regulate it the same way as Part A. That's a big change and will involve a lot more work for procuring authorities and a lot more possibility of challenge, because for Part A, once the financial threshold is exceeded, then they've got to be advertised in the OJEU, the official journal of the European Union, and you have to adhere to the prescribed formality procedures: open, restricted, negotiated, competitive dialogue, and all of the time limits that are prescribed for each of those. And there's a lot of formality in those, and there is room for challenge on those. So that's a significant change. The logic of what's proposed is that very big contracts are under Part B, and simply because the subject matter fits under Part B, it cannot be said that they're necessarily not of transborder interest. So watch the space, and there's a lot of lobbying going on at the moment, and now is the time to get involved in that if one's own interests are affected thereby as well. The financial thresholds are being maintained by the Commission, and that's again the view they've taken is that they don't want big hunks of unregulated large contracts. At present, the use of negotiation without publishing the negotiated procedure in the public sector, without publishing a contract notice or a tender notice in the OJEU, is only allowed in very limited circumstances, and they're summarised on that slide as they are under the existing directives. It's such as, for example, prior overall pricing is not possible because of the nature of the works or services and so forth. They're fairly well-known exceptions, and in fact, they're very limitation and narrowness of scope is why the competitive dialogue was introduced as a procedure as well. It was to alleviate the difficulties of trying to run complex contracts where there wasn't a clear legal authority to use the negotiated procedure. Well, now it's proposed that there's more negotiation to be allowed. And again, I'm only just summarising this. One could spend the entire day doing it. But it's proposed that there be simplified procedures and that there be a general notice for planned procurements for the coming year. And within the scope of that, then, that might replace individual contracts. It's almost like a pin triggering a negotiated procedure under certain circumstances. And it's permissible where negotiations are needed to establish the legal or financial makeup of the project. Now, that's almost like taking some of the wording out of the competitive dialogue conditions of entry at the moment, but it's still not a carte blanche for use of the negotiated procedure. There are some also caveats as to how one goes about that, and it's not permissible to change in the course of the use of those negotiations, if you like, the major elements, the subject matter of the contract, the award criteria, and so forth. Again, that's echoing what I said a moment ago about material change as well. It's reflected in that limitation on what's proposed. Again, technical specifications similarly controlled. I'll go on then to the reduction in documentation requirements. And I just mentioned it very briefly because I think Nicola will, be speaking in relation to SMEs and the reduction in the proposed reduction in the use of documentation, or the documentation that has to be furnished at the time, particularly of qualification stage, to get the bidder into the starting gates in the competition at all. Is proposed to be reduced, or in some cases it's perhaps not so much reduced as deferred, but you only get asked for the documentation at a later stage in the process. And in essence, what the Commission is proposing is a greater use of self-declaration, saying that when the time comes we shall be able to furnish the requisite documents. So Nicola will deal with that in greater detail. I'll just mention that in passing, by way of practical experience, in Ireland, the Republic of Ireland, there was an administrative measure published by the Department of Finance, which has legislative responsibility for procurement in Ireland, back in August 2010, and which enjoined the use of the open procedure for quite a large number of procurements. And within that, enjoined or required public authorities governed by it to defer within the open procedure the seeking of documentation, again with the same objective. But it has caused problems, and while it's a very laudable objective, the practical working experience has thrown up some difficulties. I don't want to throw an undue amount of cold water on it, but for example, a mandatory use of open procedures doesn't necessarily work easily for a lot of procurements. So while again the aim of the Commission initiative on this is laudable, how precisely it's done is a little bit trickier, and I'm afraid that's true of a lot of legislation in this life as well.
That's very interesting, Patrick. Continue, because we heard something about that yesterday, so we might address that in questions.
By all means, by all means.
The Irish experience.
Sure, and through Nicola as well, who has come from Brussels as well. Thank you very much indeed, Dermot. I'll pass on, because Nicola will be dealing with it in fuller detail, on just precisely how the submission of documentation and verification of qualification criteria is to be effectively proposed to be deferred. There's also provision, which again I think is a touch on it as well, encouraging contracting authorities to split projects into lots, and indeed where a large composite, it's proposed that there be an obligation to explain why that is not being done. There's also a provision which I think could potentially, subject to you, Nicola, and Nicola and I have not had a chance to discuss, so if we're slightly overlapping, please forgive us. But there's also provision which I think could be of particular interest to SMEs. For contracting authorities, member states may provide that contracting authorities governed by the member states' implementation would be permitted to provide for direct payments to subcontractors. Now, that's very timely in the present environment. It's particularly timely in Ireland, but I know also in parts of the United Kingdom, where there has been a difficulty with subcontractors suffering because either main contractors have been slow to pay, or because main contractors have become insolvent, or because main contractors are in dispute with an awarding authority. And there has been legislation on that in the United Kingdom since about 1996, I think, and there's draft legislation in the Republic of Ireland on that. So here we are at community level trying to solve a similar problem as well. And you have also in the United Kingdom, of course, national legislation on privity of contract for third parties, which doesn't exist in all of the other member states, and indeed privity of contract is not necessarily a feature of all the mainland European systems either. But suffice to say that if a subcontractor has no direct contractual nexus with the awarding authority, it may be in difficulty. And this initiative of the Commission is intended, among other things, to address that concern as well. On other elements of efficiency in the proposals, first of all, it's proposed that there be a more exhaustive list of selection criteria. Generally speaking, selection criteria have been relatively non-contentious. These are the qualification criteria, or your PQQ criteria, which typically relate to economic and financial standing, or technical capability or experience of the bidder, the bidding entity that is. They haven't been that difficult, but it's just proposed to tighten it that little bit. As I say, the financial thresholds are proposed to be maintained. And one of the reasons for that also, apart from the Commission desiring not to have large swathes of contracts, significant contracts, unregulated, is also because there are international obligations on the European Union, primarily through the World Trade Organization, what used to be called the GATT. So the Commission states that it has to respect those as well. As I say, Nicola will speak more fully on the documentation elements, I think. And again, I'll just mention very briefly the social health and education elements, because again, colleagues, and in particular I think Abby will be maybe addressing some of those as well. So I'll just mention they're summarised on the slide. These are at present our Part B contracts, therefore largely unregulated, other than the general treaty principles, or your proportionality, your equality and non-discrimination, your transparency and so forth. And it's proposed to introduce a new regime for them, really, and especially above the financial threshold of €500,000, which is quite high. And I suspect there's really quite a lot of debate to come on those. So I'll not dwell on them in particular, because I think one or two colleagues may be addressing them in greater detail. Similarly with innovation partnerships, which are frankly a device that I don't fully understand as they're set out in the Commission documentation. And again, happily, I think some colleagues will be speaking to them later on. in essence, what it is a contracting authority lining up a typically private sector enterprise with whom it enters into an agreement to develop innovative outcomes, as it were. On the rest of the legislative clarification, I've mentioned material change. And really this is a very elaborate clarification of the press-a-text rules. For those who are non-lawyers, press-a-text is a leading case from about 2008, which determines what are the permissible bounds of change, either within a contract as awarded, and therefore, if you like, a post-contract change, or in the course of a procurement. Essentially, if it's changed unduly radically, it's not permitted. And one of the circumstances in which there can be an unduly radical change is where there's a change really that's to the material benefit of the contracting authority. And in general, if there's an external, there are exceptions to that as well. And the recent WALL case, W-A-L-L, a German case, where a particular subcontractor was the key to a contractor winning its project, conveyed that the European Court regarded change of a subcontractor in those circumstances as much more problematic. But this legislative clarification will deal with things like step-in rights, insolvency, how much there can be contractual provision for the change, included at the time of the procurement as well as at the time of the initiation of a contract. So it's a tricky area, and I'll spare you all of the gory details of it just at the moment, given our time frame today. I'd just like to mention the topic of experience as well, which is, again, much clarified and very welcomely so. There is a case called Lianakis. To the lawyers amongst you, it's chew the corner of the pillow stuff at night sometimes. It's a controversial decision of the European Court of Justice in back about 2008, a Greek case, which appears to say that because experience is a classic qualification stage criterion, and bear in mind that with the exception of the open procedure, all of our procedures are two-stage. So the restricted procedure, the negotiated procedure, the competitive dialogue will all typically have a qualification stage where the prospective bidders fill in a PQQ or some other document with maybe slightly different nomenclature, pre-qualification questionnaire, PQQ, and they will state their requisite as they're in accordance with the questions posed or with the criteria set. Their economic and financial standing, their technical experience, their project experience, their and so forth. And experience is at the heart of that stage of the process. So the problem really that arose or at least that was manifest in Lianakis, was that lots of awarding authorities also wanted experience in relation to the award criteria. And Lianakis appeared to say that experience at the award stage was not permissible because it was a qualification stage criterion. People have sought to distinguish Lianakis, make it fact-specific and so forth. Then another case from Greece came up before the European Court, and it didn't appear to make it any clearer, and in fact appeared to be downright difficult. And there's been extensive lobbying on it. And some people take the view, well, if you're asking for experience that is manifestly award stage specific, well, maybe that'll be okay. And then people have tried to rationalise that and justify it by reference to the terms of the judgment and so forth. So happily, you will see there on that slide, in the middle blob on that slide, that contracting authorities is now proposed are to be permitted to take into account the organisation, qualification and experience of the staff assigned to perform in the contract as part of the award criteria. In other words, at qualification stage, you take what is the experience of the bidding entity. Yes, it has built railways, or yes, it has, it's a hospital and it has performed heart transplants, or whatever it happens to be. The experience of the bidding entity. But what the rationalisation of Lianakis, and it is a change, I think, from certainly a clarification from Lianakis, is that it would also be permitted to say what is the bid team's experience, for example, on maybe capacity to innovate or whatever it happens to be in the particular circumstances. That would be a permissible criteria at award stage. So that would certainly make life an awful lot easier, and I think it also accords with common sense if it goes through on that basis. So bear in mind, qualification stage is the bidder, award stage is the particular bid team, and not the entity. I'd just like to mention then just a couple of other, I know we started slightly late, Dermot, but just another couple of minutes maybe would be fine. Thanks very much indeed, Dermot. You're very kind. There is further support for the Europe 2020 strategy. And we've just mentioned the broad outlines of that above. And that's very important in terms of environmental and social considerations. There was a leading case a number of years ago, especially for the non-lawyers in the room, involving the procurement of buses for the city of Helsinki. And specific environmental criteria were specified. Whether they had to be dual fuel or catalytic converters or whatever it happens to be, there were specific criteria specified. And there was a fear at one stage that this was taking procurement a little bit far, and that procurement was being used effectively as a social instrument, and that wasn't what it was intended for, and were people going beyond what was initially permitted and so forth. So the court, in essence, the European Court of Justice, before whom it came from the Finnish courts, in essence prescribed that social and environmental considerations were permissible, provided that they were related and proportionate to the subject matter of the contract. So in essence, the new draft directives build upon that, and they build upon that proportionality and subject matter related principle. And they've also embarked on an elaboration of what are the life cycle elements to costs. In other words, the new directive focuses very much on cost and not just price. It's the wider dimensions. And there is very considerable treatment of what is permissible in terms of life cycle costs, including internal costs and monetized external environmental costs and so forth. And again, how they're measured. I should mention that actually relates also quite closely to what is provided in the directives on change. I mentioned that the Pressatext case was essentially being transformed and codified into legislative form. The change obligations which are contained in the new draft directives are very practical, I think. There are two main arms to them. I think we've just passed lightly over them on one of the slides there. There are two main arms to them. First of all, the scope for change must be very clearly and precisely laid out at the start, including in a contract, so that a post-contract change, post-contract award change can be controlled. And then there is also a statement that where the change can be reduced to monetary terms, where the value of the change can be reduced to monetary terms by reference to the value of the contract, that if it's less than 5% either up or down, it's deemed not material. And there has been a lot of material published since these drafts were put into the public domain, which indicates that anything above 5% is not permissible. I don't believe that's correct. I think that less than 5% up or down is automatically okay when it's comparing the monetized value of the contract. But the preceding provision, which says that provided that the change is clearly legislated for and the terms of it are set out in the contract, then it may also be quite permissible. So there's some ill-informed comment on that which really shouldn't be followed. So it does mean, though, that the basis for the change and how you'll have, for instance, your classic variation clauses in contracts need to be very, very carefully drafted. Up to now, there are standard form variation clauses in all sorts of construction contracts and supply contracts and the various contract forms, and they haven't really mattered that much. You've also got to be desperately careful, because too wide a variation clause would just be struck out, as happened in a case involving the Law Society in England and Wales, where the Legal Services Commission a number of years ago, 3 or 4 years ago, in awarding legal aid contracts to law firms, had language in their standard form contract which more or less said that the Commission could vary it as it saw fit in the circumstances. And that was struck down as being impermissibly wide and contrary to the principles of procurement law. So in between the two, careful drafting. It's actually a case where the lawyers are actually worth their salt. I think would repay a small investment in the lawyers. There's detailed provision on things like eco-labels and other environmental and social considerations, which I won't go into, and equally on social inclusion and the favouring of reservation of employment, favouring sheltered workshops and so forth, where an element of the minimum required percentage for disabled or disadvantaged workers is reduced as well. It makes it a little bit easier to operate. Again, on the social considerations, some of my colleagues will be speaking more fully to them. But it's just important to point out that amongst the grounds for exclusion is an abnormally low tender, where it's abnormally low on account of a breach of, if you like, public good or social legislation, including labour law, including environmental law. So in a way, that's, if you like, a legislative bar on a race to the bottom, which has much wider social implications. In general, you'll recall that abnormally low tenders do not have to be excluded. In fact, there might be absolutely nothing wrong with them. They may actually represent that is the market, and not for procurement officers and not for lawyers or anybody else to determine that. Again, there's a common misconception that if a tender is abnormally low, it must be excluded. Yes, there's an obligation if the awarding authority is minded to exclude it, to consult the tenderer and to pose questions and see on what basis the tender is computed and so forth. But in the end of the day, with a handful of exceptions, there's still a discretion to allow an abnormally low tender. But here is a mandatory ground of exclusion if the tender is abnormally low because of a breach, if you like, of social legislation. There is very, very detailed provision in the proposals on conflicts of interest, and frankly it's very confusing. It's not easy to follow at times, but just in summary, there's a wide category of persons who are deemed to have a direct or an indirect private interest, and then the interest in turn is defined very widely as extending to family, economic, political and other shared interests with bidders, and it relates also to advisors and those participating in procurements as well. Frankly, I suspect some of that may well change in the course of the legislative deliberations, if only to make it more practically workable. At the moment, where bidders have a limited time to compile a tender, and where contracting authorities are under pressure, first and foremost, to look for value for money and be practical, to having to check off the possibility of an unintended conflict of interest, I think could be very burdensome indeed. And candidates have to declare in particular links with a chairperson or with others in decision-making bodies, decision-making organs, as it were, within a contracting authority. There is also provision for a contracting authority to take persons who might be affected out of those decision-making organs and so forth. There's also provision for informing what's called a national monitoring body, and those decisions all have to be documented carefully. That brings us on to that national monitoring body, which I think probably is exhausting my time as well, Dermot. Thank you so much. There is provision for, it's a little bit akin to the national regulatory authority that is put in place in other sectors in all of our jurisdictions. Member States may designate it a national independent oversight or monitoring body, and it's in charge of monitoring, implementation and control of procurement. And it's provided in quite lengthy provisions in the draft directives that the body is to provide support to public authorities and businesses, and by structures and mechanisms, and by offering legal and economic advice, guidance, training and assistance. Now, in the United Kingdom, we've had, for instance, the Office of Government Commerce, the OGC, which is now migrated over with the change of government to the Cabinet Office, and has done splendid work and lots of very good guidance notes and so forth. So to be perhaps formalising something like that What has happened in other regulated sectors, just on that first blob, is that you have entities like Ofcom, Ofgem put in place and so forth over the years, and in all of the member states. One of the main drivers in the other sectors is where you had very extensive state-owned, less so in the United Kingdom, but very extensive state-owned, particularly utilities, and it was necessary to have an entity which was independent of them. Albeit funded by the state or funded under legislative authority from the state. So it was a question of how the policing is done, as it were, in order to assure all interests of an independently regulated sector. It's not clear that the oversight body will have quite such an extensive role as that, but how it will be put in place remains to be teased out with, I think, some more deliberation to come upon that. What I think generally many people might welcome would be a dispute settlement body short of the courts. I think the lawyers would be happy enough to say that at the moment judicial review, which it is in Ireland at all times, and in the United Kingdom it's not always judicial review, the remedy, but either way it's a very expensive remedy because it tends to be front-loaded and it happens very fast. The courts are being asked to determine disputes that are holding up a procurement, and particularly with the automatic suspension under the new remedies directive. I think one of our colleagues will be speaking to that later on in the day. Where once proceedings are issued at all by way of challenge under the new remedies directive, then there's an automatic suspension on the right of the contracting authority to award a contract. So effectively, if there's any litigation at all, the awarding authority must either be able to resolve the problem with the bidder, the aggrieved bidder, or alternatively persuade a court to lift the suspension. It's almost lifting an injunction effectively, and the relevant criteria applicable to injunctions are very similar. It's very expensive in financial terms, and it's very disruptive. So in many jurisdictions there is a procedure for a lower level dispute settlement short of the courts. There are, however, downsides on that, in that you may have a lower standard of justice and you may have a higher number of effectively wrong decisions. So it's not an easy circle to square. I'll bring it to a conclusion, I think, at that stage, because one could go on at great length on a number of those elements, and there are a number of very interesting colleagues coming behind me as well who would speak to particular aspects of them as well. So perhaps through the chair, if there were questions, but
I'll take questions afterwards, Pat.
Fine, grand. Thank you very much indeed.